Hey everybody. If you've been watching my content both here and on TFM's channel, you'd know that I often talk about false allegations of abuse and harassment. When discussing this subject, I almost always tell men that if they ever receive a false allegation, they should respond by going scorched earth on their accuser. While occasionally I give general guidelines on how to do this, I typically avoid specific tactics until now. Today, we're going to use feminist attorney Lisa Bloom as our case study. For those who don't know, she is the daughter of feminist attorney Gloria Allred. Gloria Allred is the ambulance chaser of sexual harassment lawsuits. Gloria Allred was also the attorney who pushed the false allegations against Judge Roy Moore during his election, which, when combined with the recently discovered facts that Democratic operatives committed false flag election fraud against him, cost Judge Moore the election. I did videos on both Gloria Allred and the Democrat false flag operation against Roy Moore. Links to both will be in the description below. Both Gloria Allred and her daughter Lisa Bloom have a long history of feminist Me Too witch hunts against men in an effort to extort large sums of money from them while simultaneously destroying innocent lives. Also, before we get started, I'm not an attorney, and nothing in this video should be construed as legal advice. These are my personal opinions alone. My opinions are not legal opinions as defined by any law related to the unlawful practice of law or any other relevant law. Nor should anything included in this video be construed as legal advice, either generally or specific to any actual pending case. With that history and the legal disclaimer out of the way, let's get started. According to Deadline.com in December of 2018, Crown Media wants lawyer Lisa Bloom off Mark Stein's home and family suit. Hallmark Channel's owner is now aiming to have the former Home and Family co-host's high-profile attorney Lisa Bloom pushed out of the case. This motion arises because defendants retained the Bloom firm, and that representation prevents the Bloom firm from pursuing this adverse representation against defendants, Crown Media declared earlier this week in a lengthy federal court filing, seeking to have the Bloom firm and its practicing namesake disqualified from the more than 2-month-old legal matter. And of course, it says read it here, and I actually did. I pulled it up. So here's the motion itself. It's the defendant's notice of motion and motion to disqualify plaintiff's counsel, and it was filed on January 7th, 2019. And as you can see, the defendant is Crown Media. Now, this is a 25-page motion. I'm not going to go through all the nitty-gritty and put everybody to sleep in the process. But if you actually want to read the motion, I'll put a link to it in the description so that you can download it and check it out. Because honestly, it makes for a really great template. But before we get started, I really kind of want to discuss motion practice a little bit. And what I mean by that is how to be successful in motion hearings. Now, if we look at the table of contents right here, now this is what's called a memorandum of law, and it's supported by both facts and legal argument. And so the first section there is obviously the introduction. The second section is a statement of fact. And the third section is argument. Now, this is the part that we're going to look at a little bit more closely. When you look at the argument section, it is split in 4 parts. There's the legal standard, which is the first section of the argument. And then the other 3 parts are individual arguments supporting the motion. In other words, the legal basis for the motion. And in addition to that, the statement of facts are the facts relevant to the motion. So think about that for a moment. You don't necessarily need to state every little fact. Don't state emotionally relevant facts. Nobody really cares about your next door neighbor's, dog's escapades chasing a bone. But, state the things that are relevant, just as a little FYI. Now, as far as the argument is concerned, this is the legal argument that supports the position. Now, the reason that this is important and the reason this makes for a very good template is because this attorney doesn't actually use a single argument. He actually has multiple reasons and justifications for filing this motion. If you file a motion without justification, you can get sanctioned for it if the other side pushes for sanctions, or if you piss off the court by saying something stupid and they choose to sanction you. I've seen both things happen. Now, when you look at the arguments that are included under Section B, it talks about how the Bloom firm is prohibited from taking an adverse position because the defendants were its former clients. Now, in addition to that, and then in Section C, they go on to state that even if the defendants were not former clients, they still must be disqualified on other grounds. And then on top of that, the final reason under Section D shows that even if the attorney was disqualified, it would not unduly burden or prejudice the plaintiff. They could find another attorney, and it's not a big deal. Now, again, the reason that this is important is because when you look at B and C, it's not just one reason to make the motion, it's every reason to make the motion. So obviously, you don't want a 150-page motion, and in many courts, there are document page limits for motions. So maybe if you're limited by 25 pages, maybe that's the only reason why this motion is 25 pages. Or maybe, you're limited to 15 pages. I've seen motions limited to up to 10 pages. Sometimes those page counts, though, don't include appendices or attachments and things like that. So those are things to kind of think about. Obviously, if somebody's practicing law in a particular jurisdiction, you're going to know what your court rules say and what the court procedure is, or at least you're going to be smart enough to look it up so you know what your page limits are and you stay within those guidelines. It's kind of a personal opinion. Of course, I can't necessarily call this a pro tip because I'm not an attorney. So there it is. But again, this is a perfect template for how to file a motion for disqualification of an attorney. Now, these types of motions are especially important in a family law setting or in a setting where you have feminist attorneys on the other side, because oftentimes these attorneys will forum shop and they will try to get a judge that they know. And you will see that, I don't know, I would say, I can't really say a percentage, but I will say this. You'd be surprised how many times I have found out that the attorney on the other side has some kind of personal relationship with the judge, or a personal relationship with the parenting investigator or the guardian ad litem or the attorney for the children, or there's some sort of conflict of interest that often comes into family law cases or cases that discuss false allegations of assault or abuse. So these things are important, and this particular motion in that sort of circumstance is extremely relevant. So that's one of the reasons that I think that this is a really good template to use as an example. And again, a link to this motion will be filed in the description. And there's another reason that I think that this particular motion is a very good template. And that is, according to page 6 at the very bottom here, Bloom also last week was thrown off a wrongful termination against Crown Media. So this motion was successful. This is a perfect example of how you file a successful motion to remove an attorney off a case. Now, this is an extremely important motion to file. And again, a lot of attorneys, especially family law attorneys, they don't want to file this type of motion. But you need to remind them that if the facts justify it, they need to file this particular type of motion, or else they're going to get a biased outcome just based on the personal relationship between the feminist judge and the feminist attorney, or the feminist parenting investigator and the feminist attorney. So these things are extremely important, and this is an extremely useful and important tool for men to protect themselves. And the thing is, any attorney who is unwilling to file such a motion when it's justified, you need to get rid of that attorney because they are not looking out for your best interests. That's extremely important. And again, the other thing that I want to touch on, or I should say the last thing I want to touch on in this case, is that under Section D, they talk about how the other side would not be unduly burdened or prejudiced. This is important because it's an argument for equity. So it's important where possible to actually outline what the equities are and how your motion is equitable moving forward, because those equitable arguments can really carry the day. These are just my personal views. Now, with that in mind, let's go back to that other article. Now, the reason this article is here is because Steve Wynn has filed a defamation suit against Lisa Bloom. A federal judge has denied attorney Lisa Bloom's motion to dismiss a defamation lawsuit filed against her by casino mogul Steve Wynn. Wynn brought the lawsuit against Bloom and her firm in Nevada last year, claiming she lied when she alleged he sexually harassed one of her clients. So before we get to the lawsuit itself, we're going to look at some of the exhibits from the lawsuit. This is the first one. This was a press release from Lisa Bloom's law firm from March 22nd, 2018. And it's a statement from Lisa Bloom. And it contains sexual harassment allegations against Mr. Wynn. Now, This is important, again, March 22nd. Now, the reason that this is going to be important, I'll make clear very soon. This is the first letter from Steve Wynn's attorney to Lisa Bloom. And it's a letter to demand for retraction of false and defamatory press release of and concerning Steve Wynn. And I'm only going to read portions of it. I have been retained by Steve Wynn to represent him in connection with the false and defamatory press release you published on March 22, 2018, a true and correct copy of the same being attached hereto. At the time of publication of the press release, no judicial action or arbitration proceeding had been commenced or was pending against Mr. Wynn by Miss Bloom's client. This letter demands the immediate retraction of the press release, its defamatory gist, and the specific false and defamatory statements that are referenced herein. This demand is directed to Miss Bloom in her individual capacity and as blank's attorney, and to blank in her individual capacity. The press release is false and defames Mr. Wynn by accusing him of conduct that conveys to the average reader that he sexually harassed blank and unlawfully retaliated against her. The press release is fiction, written with the intent of gaining publicity for Miss Bloom and causing public harm to Mr. Wynn. I assume that you may have mistakenly thought that by publicly attacking Mr. Wynn, you might also create leverage to seek a financial settlement. Your imaginative but misguided ploy included the preposterous accusation that Mr. Wynn would leer at blank as she danced at rehearsals for Showstoppers. I strongly suspect that at the time you wrote your fictional press release, you intentionally ignored the undisputed fact that Mr. Wynn was legally blind at all times you allege he leered at blank on the stage from late 2014 through late October. It is a matter of public record that Mr. Wynn has suffered severe problems with his eyesight for decades and has been legally blind since 2010. Your false allegation that Mr. Wynn leered at performers completely destroys your credibility and underscores that the accusations in your press release were false by design. So we're not going to read the rest of this letter, but I think that that's pretty much a smoking gun. Okay. It was a false allegation. It was a patently false allegation because it was impossible to be true. The man is legally blind. He can't sit in the audience and leer at somebody on stage because he cannot see them. So according to this letter, Lisa Bloom's office actually responded to that particular letter. And so this letter responds to her again. And he says specifically, you either misunderstood my letter of March 23, 2018, or you are intentionally misrepresenting its contents for your own purposes. Please review the retraction demand again, and you will see that on page 2 of 4, I clearly identified the statements from the press release which are false and defamatory. In other words, this is another demand for retraction of defamatory statements. This is their second warning. This is important. We're going to get into it in a second, but this is their second warning. Okay, so Lisa Bloom, who went to college for 7 years to get her bar card, is a slow learner because the attorney had to send her a third letter. In fact, he was so concerned about sending it, he actually emailed this letter to her. Now, these letters are part of public record. Like, I'm not doxing anybody, okay? This was part of a public record. You can actually download these links from the news website. I'll provide links to all this stuff in the description. But the thing that's important here is this is the third letter, okay? And basically he's like, look, retract it or else. And that's really what it's been saying, is retract it or else. And these are kind of the documents from the lawsuit. Now let's go up to the top for a second. This is the lawsuit itself, complaint for defamation. And it is in total, a 30-page document. And the documents that I showed you, the 3 letters, are included as exhibits to this particular lawsuit. So this isn't just a baseless lawsuit. This lawsuit not only shows that Steve Wynn is suing Lisa Bloom, but he gave her multiple opportunities to back down, and she was too stupid to see it at the time. The reason this is important is because if you're going to go scorched earth on somebody, you got to give them an opportunity to back off. You got to send them some warning letters. You got to give them some time, have some communication back and forth, show a good faith effort that, look, we gave you an opportunity to fix this, to apologize, and you chose not to do it. So now we're suing you. Now, the other thing that's important is that anytime somebody of note gets accused falsely of harassment or DV or some other kind of abuse, it's always a press release. It's always publicly available. The reason they do that is to destroy the credibility of the person that they're accusing. Now, it's not always necessarily something that's reported in the news. Maybe if you're on college campus, maybe it gets leaked out to the college public or the college population. If you go to a church, it's leaked to the members of the church. Whatever community you're a part of, these false allegations get leaked to that community. And so that causes the defamation. And they do this whisper campaign to destroy your life. And if you're a person of means, they want to steal money from you. They want to extort money from you with these false allegations. So this is how they do it. So when those things happen, you have to call it out. You can't just run and hide. You can't just, curl your head up or curl into a fetal ball and hide. You have to hit this stuff head on. You have to address it and say, no, these things are dishonest. You need to withdraw the statement. If you're not going to withdraw the statement, I'm going to take action against you. Now, obviously, in this case, what's nice about this is that Steve Wynn is in Nevada. Lisa Bloom is in California. So what does he do? He files in federal court. Well, the key to getting into federal court, according to the lawsuit, is that you have to have damages exceeding $75,000. So if you can articulate hard or soft damages in excess of $75,000, by all means, sue them in federal court. Never sue them in state court if federal court is an option, because federal court has punitive damages. And basically what that means is punitive damages are punishments. So let's say you have your actual damages, then you have soft damages like emotional pain and suffering and those types of things. Then you can ask for like $10 million or something crazy as a punishment and say, look, you did something wrong. We are holding you accountable. This is reasonable under these circumstances. I recommend everybody do this. If you get falsely accused by somebody of abuse or harassment or assault, send them some warning letters and say, look, you're falsely accusing me of this. This is wrong. And then sue them. And if there's a criminal investigation going on, who cares? Sue them anyway. Sue them anyway. But don't waive your Fifth Amendment rights. Don't waive your right to remain silent about it. Don't waive any of these things, especially if there's a criminal investigation or if there could be a criminal investigation. If you're innocent, never waive your Fifth Amendment rights. Never give people the opportunity to twist your words and to find you guilty of something you didn't do. Period. And if you are being falsely accused and you are absolutely innocent, go scorched earth. File a suit for defamation. Give them warnings. Now, in this case, they gave 3 warnings. They wrote 3 demand letters. They went back and forth and they said, back off. They didn't do it. They sued them. This is extremely important because, again, Lisa Bloom tried to have this suit dismissed and the court said no. These are perfect case studies on how to hold dishonest attorneys and false accusers accountable. So what are the other takeaways here? Well, it's pretty clear. Lisa Bloom is clearly as unethical as her mother, Gloria Allred. In the Crown Media case, the court threw her off the case because she previously represented Crown Media and was ethically barred from representing her client in that case. The court understood that, and they threw her off the case anyway, again, for unethical conduct. But that didn't matter because she's so greedy she tried anyway. Now, you can also see from the Wynn case, Wynn's attorneys presented evidence showing that Bloom either knew or should have known her allegations against Wynn were false when she made them, especially in light of the fact that Wynn has been legally blind since 2010. However, Lisa Bloom follows the feminist union contract. Lie, lie, and lie. And if you're caught lying, double down and lie some more. All feminists do is lie. As a result of feminism's pattern of dishonesty, they have no moral high ground. So never feel bad about holding one of them accountable for unethical conduct. If you're a legal professional, use the legal pleadings and the demand letters included in this video as templates of how to defend yourself or your clients in a false allegation situation. And with that in mind, it's especially important to remember the reason you go scorched earth on false accusers is because they're going to go scorched earth on you with false allegations of one of the worst crimes to be accused of. Men have been harassed, brutally beaten, and even murdered after being falsely accused of some of these types of crimes. I document many of these instances in my book, The Feminist Lie. And make no mistake, these liars are attempting to destroy your life. So in order to defend yourself, legally and publicly destroy theirs. This way, other feminists see their metaphoric corpse as a cautionary tale, and innocent men around the world will see it as a testimonial to other victims of false allegations that accountability is possible. I'm DDJ, and this has been your dose of misandry today.